Thank you for the opportunity to speak today. I'm actually a newcomer to this conference, so I thought I should start by introducing myself. I am not an art historian and I'm not a theatre historian. I'm actually a copyright lawyer, and my main research to date has been in 19th century copyright history. Now, something to flag about copyright history scholarship, until very recently, it has been overwhelmingly concerned with the laws protecting books and literary works. Now, my work is different. My focus is the visual arts. My monograph, Art and Modern Copyright, which was published by CUP in 2018, looks at paintings, engravings, and photographs in the UK 1850 to 1911. Now, whereas I'm a lawyer, my approach is most definitely interdisciplinary. The work of art historians most definitely informs my work. And I'm also interested in the ways that legal history can contribute to art historical thinking. And that's a question that I touch on in my book. And I've also got a forthcoming article coming out in the Burlington magazine this summer, exploring the disciplinary boundaries between art history and copyright history. Now, the photos here are from some of the talks I've given, my book launch at the Victorian Picture Gallery at Royal Holloway. I've also given talks connecting copyright history to particular paintings. Hunt's The Light of the World at Keble College Chapel in Oxford, also Whistler's portrait of Lady Eden at the Hunterian Gallery in Glasgow. If you're interested in my work, the first chapter of my book is available for free download as a working paper on the Create website. And you can also get a 20% discount code there for the book. So given this context for my work, the call for papers really sparked my interest. And the points in the call that I want to engage with are these. Firstly, that the 19th century was a time of great boom in transmedial culture. And further, that there were blurred boundaries between art and theatre, that art and theatre were closely interconnected in the sense of the pictorial nature of theatre and the dramatic nature of art. And I think there are really two aspects to this humanities account to which copyright history can contribute. First of all, how was transmedial reproduction regulated in the 19th century? So what was the legal context that facilitated this boom in transmedial culture? And that's particularly interesting, as we're going to see, because the 19th century is a time of expansion in the idea of copyright infringement. The second way in which the synopsis in the call for papers really caught my interest concerns its implications for how we understand the relationship between law and aesthetics. So in my book, I explore, amongst other things, the implications of aesthetic thought for copyright, the way that on a level of general principle, the perceived connections between art forms did matter to copyright in the 19th century. So copyright law is premised on a particular aesthetic understanding of art forms and how different art forms relate to one another. And what I'm going to argue in this presentation is that in the law facilitating transmedial culture, the connections between legal and aesthetic ideas were very much severed. So far from conceiving of art and drama as interconnected, the law conceived of these two media as fundamentally different in nature. So it's a kind of paradoxical conclusion. The interconnections between art and drama could flourish in the 19th century because the law perceived them to be fundamentally different, and therefore the one didn't infringe the other. So with this introduction, let's now turn to some copyright history. I think there are 2 points about copyright history to flag at the outset. First of all, the piecemeal nature of copyright history developments in the 18th and 19th centuries. So the first Copyright Act was passed in Britain in 1710, and protecting books, and further piecemeal acts protecting other subject matter were then passed during the course of the 18th and 19th century. Engraving was protected by acts of 1735, 1767 and 1777, sculpture by acts of 1798 and 1814, and then paintings, drawings and photographs by the Fine Arts Copyright Act of 1862. So by the early 20th century, there were some 21 different copyright acts, and there were totally different rules for different subject matter. Now, all of that changed in 1911 when these acts were repealed and were replaced with a single Copyright Act premised on the general principle of treating all copyright subject matter together. The second kind of big picture point about copyright history that you need to understand is the huge transformation in the idea of copyright from 1710 to 1911. So in the 18th century, copyright was conceived as a narrow right to control printing and reprinting. And by 1911, the idea of copyright had been transformed into a broad right to control a very broad range of uses of a work. So by 1911, it's clear that the copyright owner can control transmedial reproduction into different dimensions. So a reproduction of a two-dimensional work into three dimensions, or a three-dimensional work into two dimensions, will be an infringement of copyright unless the copyright owner consents. And that rule is set out in section 1, subsection 2 of the 1911 Act, which prohibits reproduction in any material form. So the position is clear by 1911, and it is an infringement. But what about the position before 1911? Well, under the Engraving Acts and the Sculpture Copyright Acts, the assumption was that transmedial copying 2D to 3D or vice versa was not an infringement. So the assumption is that the infringement clauses confer a narrow right to copy. So, for example, in Dix against Brooks, decided by the Court of Appeal in 1880 under the Engraving Acts, a work of a different class intended for a different purpose would not infringe engraving copyright. And the example given by the court is that the reproduction of an engraving by waxwork at Madame Tussauds would not infringe engraving copyright. And I think this narrow understanding of engraving copyright as a narrow right to print and reprint in part explains a decision of the Court of Equity in Martin against Wright, decided in 1833. So the artist John Martin brought an action under the Engraving Acts, arguing that a reproduction of engravings of his paintings, Belshazzar's Feast, as a large-scale diorama, which was exhibited at the Queen's Bazaar in Oxford Street, was an infringement of copyright in his engravings. And the court conceived of this as a case about unauthorised exhibition, not copying. So Lord Shadwell was of the view that the Engraving Acts were confined to cases of infringement by printing, publishing or selling copies, and not exhibiting for profit, which is what the court considered the defendant to be doing. So the Engraving Acts, as I say, were understood to confer a narrow right to copy. And really the first artistic copyright act that might facilitate a different, more expansive view of infringement was the Fine Arts Copyright Act 1862. And this was passed at a point at which a more modern conception of copyright was starting to take hold in legal and scholarly writing. But before we turn to the Fine Arts Copyright Act 1862, however, I just want to say a few words about a case decided in 1860 to 1861 by the Irish Rolls Court in Turner against Robinson. So Turner against Robinson concerned the painting The Death of Chatterton by Henry Wallace. The question was whether the painting was infringed by the defendant photographer's stereoscopic slides. The defendant had photographed a model that he had posed so as to imitate the design and outline of the painting. Now, there was no statute protecting painting at this point. However, there was protection for copyright at common law for so long as works remained unpublished. And the Irish Rolls Court in Turner against Robinson held that The Death of Chatterton was at this point an unpublished work. And it was held that the defendant's slides infringed copyright at common law in the painting. Now, I think this decision is significant in that it was underpinned by a very expansive idea of copyright that goes beyond a narrow right to print and reprint. Perhaps it was signalling where the concept of statutory copyright would eventually go, certainly by 1911. But interestingly, neither artists nor the owners of paintings sought to rely on this decision. And this was perhaps because there was real uncertainty over who owned common law copyright in the case of a painting, so whether it was the owner of the painting or the artist. And I think it is this confusion that led to the focus on the grant of statutory protection for paintings. And I'm going to spend the rest of the presentation looking at the position of transmedial copying involving a change in dimensions under the Fine Arts Copyright Act 1862. So you'll remember the 1862 Act remains on the statute book until its repeal in 1911, when, as I've explained, such copying clearly came within the control of the copyright owner. So the 1862 Act, it protects paintings, drawings, and photographs. Section 1 states that protection was granted to paintings, drawings, and photographs and the design thereof. So that's language that a court could use in what was a more modern late 19th century context for thinking about copyright to cast the rights of the copyright owner in more expansive terms. And the question arose in a case about theatre commenced in 1894, which went all the way from the High Court to the Court of Appeal and was finally decided by the House of Lords in 1895. The case concerned copyright in paintings. The details of the paintings are at the bottom of the slide, and the paintings were reproduced as living pictures at the defendant's music hall, the Empire Theatre of Varieties on Leicester Square. So at a particular point in the performance, which comprised a variety of music hall acts, a huge gold frame was brought onto the stage and the various paintings were reproduced or represented through the posing and dress of the actors and the various accessories. So there are two points about copyright infringement. The first allegation of copyright infringement was that copyright in the paintings was infringed by their reproduction as living pictures on stage at the Empire Theatre. The second allegation of copyright infringement was that copyright in the paintings was infringed by sketches of the living pictures, which were made by journalist artists who attended the performance at the Empire Theatre. And the sketches were reproduced in two illustrated papers, the Daily Graphic and the Westminster Budget, as a means of reporting on the performance. So I managed to track down a really quite complete set of the court documents about the case at the National Archives. And really interesting is the evidence of the claimant, Franz Hanfstengel, who's a German art publisher who owns copyright in the paintings. And his evidence explains to the court his concerns and why he decided to bring the action. And certainly having looked at some of the theatre history literature, it feels a little curious as to why it's not until the 1890s that we get a copyright case about whether living pictures infringe copyright in a painting. So in Victorian Spectacular Theatre by Michael Booth, Booth remarks that living pictures were common in the theatre from at least the 1830s onwards. Also, the theatre historian Robert Whelan, this is in an essay in the anthology Frith, the People's Painter, he's written about the numerous paintings of modern life by the well-known Royal Academician painter William Powell Frith that were reproduced as living pictures at the Drury Lane Theatre. And interestingly, while Whelan doesn't discuss whether these reproductions were with Frith's consent, he very much sees these depictions as positively contributing and supporting Frith's claim to be the people's artist. So Frith was famous for his depictions of modern life in painting, particularly crowd scenes, and Drury Lane was seen as the people's theatre. So Whelan argues that the living pictures were adding to Frith's popular reputation as an artist. Now, what's interesting about the witness evidence of the claimant in the Empire Palace case is that it is clear that he wants to establish that owners of copyright in paintings can prohibit the representation of those paintings as living pictures. It's not just a case about no royalty being paid, it's a case about injunctions. So why does the copyright owner, Franz Hanfstengel, want to do this? Well, he didn't like the fact that the Empire Palace was a music hall. He complains that there were a number of, and I quote, vulgar variety acts included in the same performance. For example, the grotesque gymnasts, the wonderful donkey and the baboon. And the claimant notes the wonderful praise for the artistry of the living pictures in the newspaper press. For example, in his statement, he quotes from the Daily Telegraph that had praised the Empire Palace's living pictures as, and I quote, a notable example of variety theatre offering for popular approval an item purely artistic and artistically pure. And the claimant's concern was that because of this great praise, that there is every probability that the fashion of making such representations of notable pictures as living pictures will spread to music halls generally. So the claimant is concerned that the use of his pictures in this way will become a more general practice. And the consequence would be, he said, that, and I quote, my copyright pictures would become hackneyed and common. They will be vulgarized and consequently reduced in value as works of art. So that's the context for the case. What did the courts decide? So first up is the case brought against the Empire Palace. So the claim that the living pictures infringe copyright in the paintings. And the case is first heard in the High Court by Mr. Justice Sterling, who holds that living pictures do not infringe copyright in the painting. And that ruling was upheld by the Court of Appeal in a decision of February 1894. So why do living pictures not infringe a painting? Well, the claimant's case very much relies on the words of the Fine Arts Copyright Act 1862, that the scope of copyright extends not just to a painting, but the design thereof. So the living pictures, it is alleged, reproduced the design of the pictures. The courts disagreed. The 1862 Act prohibited reproduction, and living pictures were not a reproduction. Lord Justice Linley in the Court of Appeal said that what the Empire Palace had done was not to reproduce, but to represent the pictures, to dramatise the pictures. And Lord Justice Linley contrasted the words of the 1862 Act, restricting reproduction, to the words of the Dramatic Copyright Act of 1833, protecting dramatic works, which expressly prohibited representing or causing to represent a dramatic piece at a place of dramatic entertainment. As Lord Justice Linley explained, the purpose of the 1862 Act was, and I quote, to protect painters from having the commercial value of their productions impaired by the reproduction by any means of something of a character similar to that of which they were authors. So it was not intended to lay a totally different class of people under restraint, to limit the scope of an actor's business. So living pictures are held not to infringe because, as a matter of law, painting and drama are thought to be very different. So that was the action against the Empire Palace. But what about the reproduction of sketches of the living pictures in the Daily Graphic and the Westminster Budget? Do the sketches infringe copyright in the underlying paintings on which the living pictures were based? Well, at first instance, Mr. Justice Sterling held that they were infringements in the sense that they were copies that could be subject to forfeiture. But this decision was unanimously overruled by the Court of Appeal and finally by the House of Lords in December 1894. So the House of Lords held that while it was possible for copyright in a painting to be infringed by sketching from a living picture representing it, there needed to be a requisite resemblance between the painting and the infringing sketch. In this case, only the general subjects of the paintings and the sketches were the same, and the sketches did not capture the particular treatment of the subject in the painting. Also a factor laying in favour of the defendant was that the sketches were taken not from the claimant's copyright works, but from scenes represented by living actors. I quote, they were merely intended to inform the public of what might be seen at the Empire Theatre. So what are the responses to the decision? Well, in the art press, there were some articles which acknowledged the benefits of the decision. So the Magazine of Art, for example, acknowledged the view that, and I quote, any injury which might be caused to the individual will result in a gain to the many by the elevation of public taste to appreciate artistic representations on the music hall stage of subjects suggested by the best examples of pictorial art. But that view was far from universally endorsed. So in 1900, there was a select committee of the House of Lords on copyright reform, and one of its members was Lord Davy. And Lord Davy had been one of the Court of Appeal judges who decided the case against the Empire Palace. And in the course of questioning a witness, Lord Davey commented that, and I quote, "the copyright world were very angry with the decision and thought we were very wrong." And he went on to state, and I quote, "the effect of the decision certainly was that large fortunes were made by people like the owners of the Empire Palace who did nothing at all towards encouraging the artists to produce these works of art." And this is actually a viewpoint which echoes the evidence of one artist that gave evidence in the case against the Empire Palace, the Royal Academician painter Marcus Stone. So Stone, who was a witness for the claimant, commented in the courtroom that if his own pictures were reproduced by living pictures without his permission, he should consider he was injured because money would be earned by his work without his getting any of it. And I think these comments, both by Marcus Stone at the Living Pictures trial, as well as by Lord Davey to the Select Committee of 1900, are really indicative of a wider conceptual shift in thinking about copyright, which was taking place in the 19th century. The broadening of the concept of copyright from a narrow right to print and reprint to a broader and more modern right that we have today to control a far wider range of uses of a work and to receive the money stemming from such uses. And certainly the debate over these conflicting positions about the concept of copyright formed an important context for the boom in transmedial culture, which has been noted by humanities scholars. Thank you very much for your time.